Hello, everyone. Today, we're going to talk about the June bulletin, the June Visa Bulletin, and how it will impact your case. I am attorney Dalia Castillo. For those of you who is joining me for the first time, before I get started on this video, I want to remind you that I post videos like this every Wednesday at 12:30 on at least in English at 12:30 on immigration topics. At 12 o'clock, I do it in Spanish. If you would like to receive updates when I go live, you can like my page and share the video. If you're watching this on YouTube, please click subscribe below to our channel and then click the bell so that you'll get notified every time a new video is uploaded, so you can be on top of your case. Okay, so as of last week, immigration reopened. So now we're going to talk about the Visa Bulletin. And the Visa Bulletin is for people who have to process their visa application at a U.S. consulate in whatever country you are from. Okay, so the June Bulletin for 2020 has had quite a few changes, especially to the F2A category, which the spouses of green card holders and children and their children under 21. So what I'm going to do here is I'm going to share the Visa Bulletin with you so we could look at it while we're talking. Okay, let's see. Yep, do it this way. Okay. So as you can see, first let's talk about when you look on the Visa Bulletin, it's broken down into two dates. You have what's called the final date, and then you have what's called the filing date. So what the Visa Bulletin does is it tells us how long we must wait for a particular visa category to open up. Okay, it's broken down into preference categories, as you can see, F1, F2A, F2B, and I have here like the different family sponsor. Like for example, F21 is for unmarried sons and daughters of U.S. citizens under over 21. And then F2A is for spouses and children under 21 of green card holders. Okay, and so particularly today, I'm going to focus on the F2 because as you can see, the C is indicative of current, or it indicates that particular visa category is current. So the final date tells us when the National Visa Center or the NVC is actually processing your case. And if you are here in the United States, you may have an opportunity to file for adjustment of status. Okay. If you are outside the U.S. and your visa is current, this is where the NVC will send your case to the consulate for them to schedule you for an interview. If you are looking at the bulletin and you're looking at the filing date, that means you haven't paid the visa fees yet. When that date on your receipt notice shows that it's on that list, then you'll be contacted by the National Visa Center or the NVC. They'll send you an email with an invoice saying you need to pay these fees, and then you can submit your application to them. Then when your date is current on the final action chart, like I have here, the NVC will send your application to the consulate for them to schedule your interview. If you look at the bulletin here for June, the final action date for the F2 category is current. This means people who are currently here, like I said before, who want to adjust status, may be able to do so. So they can actually file the I-130 and 485 and send it directly to USCIS, because all these visas based on the June bulletin is immediately available. Now, there's something that you have to be mindful of. That is, if your petitioner is a green card holder, you, the foreign national, the beneficiary, must be in status. You cannot be out of status because you are filing as a spouse of a lawful permanent resident or child under 21 of a permanent resident. And you will not be considered an immediate relative because you are not the spouse or child of a U.S. citizen. The reason is you are, put on a waiting list and given a preference category. And this is what this bulletin shows, because they only issue a certain amount of visas per year. Whereas for a U.S. citizen, there's always a visa available for their immediate relatives. Okay. So if you are out of status, because it's important, you have to maintain lawful status. You can't overstay your visa if you're here on a tourist visa. You can't overstay it, because by the time you submit the application, you need to be in status, and by the time you go to the interview, you need to also be in status. If you are out of status when you apply for the adjustment of status, then you will not be able to apply for adjustment of status, even if you entered the U.S. lawfully, like I said, with a tourist visa. You will have to wait until your spouse either becomes a U.S. citizen, or they'll send your case to the consulate outside the U.S. Now, if you fall into some exemption, which is a 245I, which means a petition was filed for you, either an I-130 or an I-140 was filed for you before April 30th, 2001, then you will be exempt. If you're out of status, then you can use this 245 to exempt you from the inadmissibility charge. Okay. So all of the categories on this chart, like the F1, the unmarried sons of the U.S. citizens over 21, and the F2B, unmarried sons and daughters of permanent residents, and so on, must follow these people they should have already, submitted their civil documents and pay their fees. So these people are getting ready to be scheduled for their interviews at their consulate. Okie dokie. So let's look at the employment bulletin. Okay. So if you look at the employment bulletin, I only selected, there are more. If you go to the Visa Bulletin page, you'll see a lot more country. I just focus on these countries here because that's mostly who I deal with. And so you have the first, like EB1, EB2. Now, you see all these are current, right? These are, like I said, the same rule applies. Now, if you look at the fourth category, I have a lot of what we call special immigrant visa, special immigrant juveniles. These are people who came across the border as children or under 18. And they basically were alone, and you have to show that they were abused, abandoned, or neglected, and there's like a process to it. But certain kids can qualify for this visa. But this particular category, especially if you're from El Salvador or from Central America, it's been, crawling like a turtle, and been very slow. But now there's like a 4-month movement, and as you can see, we are now, as you can see, the date December 2016 for these people from Honduras, Guatemala, El Salvador, can file for their visa right now. But like I said, it's moving slowly. But I always tell my, especially the Central American, my Central American clients who fall under this category, you don't get married, because if they end up getting married, then that's it. They cannot, they will no longer be eligible for this particular visa. Okay, so I think we'll probably see the same pattern for the July Visa Bulletin. So we'll see. But it's important to note, if you are in the US now, USCIS is accepting adjustment of status applications. If you have a final action date, like if you're under the family base preference categories, they are accepting the dates current, that is May 1st, 2020. So I hope this information was helpful. If it was, please share it and like our page. As I said previously, I also want to remind you to do a consultation with an attorney for your individual cases, because every case is different. Because you may never know. You probably would be eligible to adjust status if you fall into this category. So I would strongly suggest that you find an attorney and talk to them one-on-one and get advice on your individual facts, your individual case. This information that I'm giving is in general. I don't know your case individually, so I can't tell you what's your case, if you would be eligible to adjust status, without you meeting with me to discuss your particular case. Again, I am Dalia Castillo, and I'm here every Wednesday with a new topic on immigration. I will see you next time. Take care.